All right, let's be on the record. Case number 2019-CR1147, captioned State of Kansas versus Zachary Arnold. Would the parties announce their appearances, please?
May I please the court, the state of Kansas appears by Assistant District Attorney Kayla Rayler.
Your Honor, may it please the court, the defendant, Zachary Arnold, appears by way of the Zoom video platform, along with his attorney of record, James Fees.
All right. So just to kind of set up where we're at this morning, back in November, Mr. Roberts, who works for the county here, did a preliminary assessment of the defendant's competency to assist in his defense and stand trial. He found that lacking, and when we do that preliminary finding, our normal next step is to refer somebody to Larned State Hospital for them to receive another assessment, and then if found necessary to undergo treatment with an eye towards resolving the competency issue and returning the defendant for trial. Mr. Spees a few days ago filed a motion to stay that transfer, desiring a new evaluation. I've really, since that time, kind of reviewed it. It is quite an old evaluation now. Mr. Spees also filed this morning a supplemental written motion and a demand for jury trial on this. Let's take up the jury trial first. Mr. Spees, this seems to me to be a purely legal question of whether a person is competent to stand trial or not. And like I said, I just saw this morning. So are you aware of any specific right that a person would have to have a jury determine their competency?
Judge, I refer to the court in my motion to KSA 22-3302, which states that, well, and actually 3302, 3 big A, the court shall determine the issue of competency and may impanel a jury of 6 persons to assist in making the determination. So it is statutorily provided that the court can do so. And, you know, again, maybe we don't have to get to that point, Judge. My primary focus at this point in the game, and I'm kind of going beyond what the court asked me, is, as the court itself stated, that evaluation is rather old. And considering the age of the evaluation and how long we expect people to get for people to get to Larned, I think that it would behoove the court to have my client reevaluated based upon the information I provided in my first motion.
All right. All right. So let's take these. I wanted to address that first, but I'm really interested first in the state's position on Mr. Spees' first request, that is that Mr. Roberts reevaluate the defendant at this time. Ms. Rayler?
Well, Judge, under the statute, once a person has been deemed incompetent, as was done by Mr. Roberts of the Wyandotte Center, then 223302 subsection 5 says that the court shall proceed in accordance with 223303. 223303 says that a person shall be committed to Larned State Hospital. We have not reached Larned State Hospital. I understand everybody's frustration with Larned State Hospital. I understand it is slow and that it has taken significantly longer due to COVID. But that is the statutorily prescribed mechanism. Now, I understand that under subsection 3 of 3303, that if reasonable grounds exist to believe that a defendant who has been adjudicated as incompetent to stand trial, the court in which the criminal proceeding is pending, if there are reasonable grounds to believe that a defendant who has been adjudicated incompetent to stand trial is competent, the court in the criminal case pending can have a hearing in accordance with 3302. The only evidence that the defendant may be competent is Mr. Spees. He hasn't seen a psychiatrist yet. So the state believes that we need to go ahead and have Larned evaluate him. And then if Mr. Spees disagrees, he can get his own independent evaluation. I believe the request for the 2 psychiatrists are to determine competency prior to him being ordered to Larned. To be honest, Judge, we're in uncharted territory all around. We're in uncharted territory with this motion. We're in uncharted territory with COVID. I have defendants who have been waiting 8 months to go to Larned. I don't believe that the statute provides for us to go backwards at this point. But the court is the one to make that determination.
Well, yeah, when you say you've had defendants who have waited 8 months, I assume that Mr. Arnold is one of those, since the referral was in November, and here we are in August. So yeah, we've been at it for 9 months. Look, I think that ordering Mr. Roberts back up to see the defendant and reevaluating him because I think everybody shares the goal in determining Mr. Arnold's current competency, and if there's a deficit in that, getting it treated so that we can resume these proceedings is everybody's goal in this case. So I think that the quickest way to do that, if Mr. Spees is accurate, and there's no reason for me to believe that he's not, although I don't have any information one way or another, Mr. Roberts might go back up, talk with Mr. Arnold again and say, given the results of his medication and simply time, I no longer believe that he's not competent to stand trial. Then we can short circuit all of this. I don't know when, I signed that order to stay his transfer to Larned. Mr. Spees, did we have a date that we believed that was finally going to happen when I did that, or it was just that we didn't want it to suddenly surprise us while we waited on this hearing?
The latter, Judge, the latter. I don't have a date that he's projected to go to Larned.
All right. So I don't see the harm in asking Mr. Roberts to go back up again, because let's face it, if we send him to Larned based on this, and the fact is that his medication over the last 9 months, the time, just his current state is changed to the point where we send him to Larned, Larned gets him, goes, this guy's not competent, send him back. We've wasted all that time. So I don't see the harm in ordering Mr. Roberts back up to evaluate him. I'm going to do that today, and then we will see where we get from there. Once Mr. Roberts evaluates him, if he still evaluates him as not competent, then I'm going to take up the other motions of independent counsel and a jury trial. I think that statute, now that I've had a brief opportunity to take a look at it, is permissive, but certainly not mandatory. It says that I can impanel. Somebody's going to have to convince me before I grant a jury trial on the issue of competency, why they feel that a jury of 6 lay people can make that or assist the court in making that decision in a really, I don't know, expedited manner. I don't want to sound like I just want to rush everything, but justice delayed is justice denied. So before I get to that point, my hope is this, that with the new information that Mr. Spees has provided, that Mr. Roberts finds that competency is no longer an issue and we can move on from that. If that's not the case, I'm going to immediately set another hearing and we will take up the demand for the jury trial and the request for the licensed physicians or psychologists. That one, to me, seems a lot more likely to give me information that would assist me in making that decision than impaneling 6 jurors to make that decision. So in any event, that's the court's order today. I'm going to order that Mr. Roberts reevaluate the defendant and submit his report as soon as possible. The other 2 motions will be taken under advisement until we receive that report. Comments on those rulings, Ms. Rayler?
No, Your Honor.
Mr. Spees?
No, Judge. Do you want one or the other of us to prepare the order?
Your motions, your orders.
I'll have it to you shortly.
Yeah, submit it to Ms. Rayler. You all submit it to me, e-file. I'll sign it immediately.
Thank you, Judge.
All right, anything else for our record today?
No, Your Honor.
No, sir.
We are adjourned. Thank you, everyone.